I want to touch on a fundamental question with you, because it's essentially a discussion about justice. And what you just said now, like the type of reform that you're advocating for is essentially trying to bring back a factual basis to these plea bargaining agreements, which very quickly can go off the rails and start creating a parallel reality with very little connection with the facts. But fundamentally, I believe that this is also a discussion about the relative importance of innocence in our society. Okay, I mean, a lot of people, whenever we talk about justice, some people roll their eyes like it's relative and your concept of justice and my concept of justice. I would strongly disagree. I think that when, under the same set of rules, the outcome is 2 years versus 20 years, or when there's a wrongful conviction, or even when there's a plea bargain with no factual basis at all, I think there's an inherent concept of justice and fairness that's violated. And the idea that I want to zoom in on with you is the idea of protecting innocence. And, in the legal community, we're very aware of this issue, and even the general public knows about the presumption of innocence, how effectively it plays out in real life situations when the facts get, diced up and organized and sequenced in different ways. How does the presumption of innocence really play out? That's up for debate. But there is another, even more fundamental idea of the relative importance of innocence versus punishing guilt. So protecting innocence versus punishing guilt. And I believe it was first expressed by William Blackstone in the 1700s. It's known as Blackstone's ratio. It's better that 10 guilty persons escape than that one innocent person suffer. It's also expressed by one of the founding fathers, John Adams, who wrote that it's more important that innocence be protected than it is that guilt be punished. For guilt and crimes are so frequent in this world, and I'm quoting, that they can't all be punished. But if innocence itself is condemned, then the citizen will say, whether I do good or whether I do evil is immaterial, for innocence itself is no protection. And if such an idea were to take hold, that would be the end of security whatsoever. You're at the very forefront of the battle against wrongful convictions. Do you believe that the justice system, and I'm asking you a tough question because I'm asking you for a generalization, but do you believe that the justice system today, and perhaps the culture more generally, takes innocence seriously enough? We seem to be very passionate about punishing guilt, but are we as passionate as we need to be about protecting innocence? And what are some of the patterns that you see around this issue of wrongful convictions?
Sure. Well, I would answer that with a definitely not. We are not passionate enough about protecting the innocent. I saw a lot of injustice that took place over my 14 years as a trial court judge. And, just injustice can come in many forms. That can come in the form of someone who most likely is guilty and not being held accountable for various reasons. The state may have not convinced the jury that a guilty person is guilty beyond a reasonable doubt, which is a standard that protects us all. And but truly, in my opinion, the worst form of injustice that can occur in a democratic society is being convicted for something that you didn't do and having what we value the most, our freedom, taken away from us. But what I see in the culture that I observed for 14 years and that I continue to observe is placing the importance of finality or resolution of conflict over the truth. And you see in our adversarial system, in the post-conviction area, where someone wants to come before a tribunal and demonstrate, either through the discovery of new evidence, someone recanting the fact that they were convicted by junk science. They want to demonstrate that to a tribunal, and they have to fight tooth and nail in this system to even sometimes get a hearing. In Ohio, you may claim to have this evidence, but you are not entitled to a hearing. The judge can list. You can put this in the form of a motion for a new trial. The state can oppose it and say whatever they want. And trial court judges are not required to have a hearing to air these claims out in open court. And sometimes they languish for years on judges' dockets. They don't have the protections that we have on the front end of the system, like speedy trial rights and the right to counsel in post-conviction. So the stars really have to align for someone who claims that they're innocent in order to get a second look at their case. And that is just sad commentary when you see the human suffering, and the fact that if you have the wrong person incarcerated, that usually means that the person who perpetrated the crime is still at large and most likely victimizing someone else. So I can't understand why we can't find more common ground on this issue of improving the system for innocent people.